So how do personal injury claims work in Ohio? It's really a step-by-step process. And generally speaking, you have your incident, which then leads to medical treatment. And at that point, you've got to collect the evidence. The evidence being whether it's medical records or bills, reports from doctors. You've also got the evidence that has to come from the liability side, which is simply what happened. Do we have police reports? Do we have reconstruction reports? Do we have an incident report? Do we have photographs? Do we have 911 calls? So all of that leads up to building your claim, building a strong claim. And if we can accumulate everything and present it to who it may be an insurance company, it may be a defendant, to try to negotiate the strongest and best settlement we can. And then if that doesn't work, then we're set for trial and we can litigate a case as well. So with all civil litigation in Ohio, it started with the plaintiff, who is the person asserting the claim in a court of law, filing a complaint. The complaint lists out the details, which are the facts of what happened, the legal claims, whether it's negligence or any other type of legal claim you may have, and then laying out a request or a prayer for relief, which is usually in a civil case, the only thing you can really ask for are money damages in most cases. Once the lawsuit is filed, we're there. We represent you from the very beginning, drafting the complaint, receiving the response from the responding party, the defendant in these cases, which is usually an answer, and then going on into what we call the discovery phase. The discovery phase is simply our opportunity to peel back the layers of the onions of the why it happened, how it happened, and really get into information that we're not privy to outside of the court system. So we use those tools to understand what happened and why it happened. There's a juncture at every case when it's filed that there may be an opportunity to resolve the claim, and we do that through direct negotiations or mediation, which is just using a third-party neutral to assess the situation and to see if the two sides can come together to resolution. And if that fails, then you've got your jury trial, and that's the last line of defense in the civil justice system.